Hello, I'm John Hartgen. I'm ABI's Public Affairs Officer, and we're shooting on location at ABI's Views from the Bench program in Washington, D.C. And we're pleasured to be joined by Alexa Kranzley of Sullivan and Cromwell, based in New York City, who is fresh off of her panel on confirmation challenges. And there were a lot of good issues discussed today by your panel of judges, Alexa. Allowance of unmeasured interest, make-whole provisions, and a lot more. So for the practitioners and viewing public out there, what were some of the insights that you gleaned today from the judges panel?
I think that there were two big ones that stuck out as a theme through all of the topics that we discussed. One that I thought was really interesting was the bankruptcy judges' views on how their opinions differ from those of the appellate court. With respect to both the unmatured interest and the make-whole, that the judges, because they're trial judges and have much more familiarity with the actual Chapter 11 proceedings, are looking at all of the considerations. Whereas, while they still want to stay close to the bankruptcy code and make sure that there's statutory basis, they did seem to note that that was an important consideration for them, whereas when the issues are before the appellate level, it's a totally different ballgame, and that they're focused entirely on statute as opposed to any of the practical and maybe policy considerations. So I thought that that was an interesting perspective that Judge Lane and Judge Owens had both mentioned in different contexts. So that was interesting to know that the judges at least are fully paying attention to everything going on in the case and are understanding of what the parties are going through. So I thought that that was an important point. And the second one is the emphasis on the judges reading very carefully what the parties contract to. And so I think that that's a lesson that all the practitioners can learn, that the judges are going to review the contracts and are not going to try to rewrite anything, and so that the parties should be very clear what their intent is. And that was echoed, I think, by all four of the judges in their opinions about make-wholes, about interest, about liabilities, etc.
Sounds like it was quite an interesting panel today.
It was definitely very interesting, and it was also, we had a lot of interesting conversations even leading up to it in debating these issues, since the judges all had differing views on them.
It sounds like these issues are ripe for continued discussion at future ABI events. And so thank you very much, Alexa, for being on the panel and joining us here today for this segment. And if you'd like to find out more about future ABI events, make sure to visit abi.org/events. Thank you very much for joining us, Alexa.
Thank you.